box with mine, and I might touch briefly upon count 10, but then address count 11, and then I guess Attorney Ball would go in response to both, and then rebuttals.
Okay,
And that's fine with us.
that's fine with you?
Yes, sir.
Ms. Silverman, how much time do you want to use?
I think we talked about basically splitting the 30,
15?
because we didn't practice it that way, but we're basically splitting it half and half, I guess.
Okay, so 15, 15, 30, and then we'll deal with rebuttal.
And I'll be amazed if I really take 30, but we'll see.
I just want to make sure everybody has an opportunity to have their say. So, okay, with that
Thank
understanding,
you.
Ms. Silverman?
Good morning. May it please the court. My name is Susan Silverman, and I represent the appellants in appeal number 2D22-502, the three nonprofit entities, Judicial Watch, Leadership Institute, and Project
Can I
Veritas.
ask you a quick housekeeping question about your three clients?
Yes.
I wasn't able to figure this out to my satisfaction. The end game where the trial judge left this, it would be that all of your clients' interests were wiped out. Is that right?
Yes.
Or does leadership still have what was bequeathed to it before the 2018?
I think in the 2016 leadership was a default
It
beneficiary.
was the only one.
It was the only.
Right, and so it's still under the order that the trial court issued. Leadership still has at least some contingent piece of this,
It certainly does not have vested interest under that, but
but it has an interest.
I believe so, yes.
And the other two, Judicial Watch and Project Veritas, I don't know how to say that word.
Veritas.
Veritas, they weren't in as of 2016. So under the trial court's interpretation, they're totally out.
Correct.
Okay, I'm
They-
sorry.
yes. They were only named in the 2018
Okay.
statement.
But leadership, and I was just trying to figure this out because of the posture of your client's appeal. And so
I appreciate it.
it's probably not the most important part of the case, but I just needed to understand.
Yes, leadership was the only one mentioned, and they were mentioned in the 2016, which the court approved.
They
of.
still theoretically have some contingent interest.
Yes.
Okay.
Now, both of these appeals arise out of a final partial summary judgment in appellee Paul Grassfield's favor on counts 10 and 11 of the amended complaint. My argument is going to address count 10 because that is the only one that affects my clients. Basically eliminated 2 out of the 3's interests as remainder beneficiaries of the decedent, Bruce Grassfield's trust. The trust was created in 2003 by Bruce and was amended and restated several times. Bruce died on August 21st, 2019, and at the time of his death, he was married to his surviving spouse, Violetta Grassfield, the appellant in the related appeal. As to count 10, Paul's position on summary judgment was that all of the trust documents created after the 2016 amendment and restatement to the trust were invalid because Bruce did not substantially comply with the method to amend included in his trust. And relevant to that issue, on December 14, 2014, Bruce restated the trust, and Article 2A reserved him the power to amend or restate the trust by.
Which gets us to the nut of the case.
Exactly.
Delivery, substantial
The method.
compliance.
The method, exactly. And the method in the trust was an instrument in writing, signed by the donor, acknowledged before a notary public, and delivered to the trustee during
The
the donor.
trustees, as that term was defined, because the term trustee is defined specifically to mean all of trustees at that time.
Yes, there is a provision in the trust that says reference to a trustee Is to
always-
single, multiple,
And there's more provisions that talk about all actions have to be made by unanimous acts of the trustee.
understood.
But the delivery, whether we talk about steps or methods or, you know, half methods and full methods, where we wind up is, does the failure to deliver the notice to Paul constitute substantial compliance? Does that render substantial compliance not to have happened? Or did the donor substantially comply by delivering to himself and not to Paul, right? That's what the case turn, both cases turn on
Yes,
that.
agreed. And
So we got a
the
huge record and hundreds of pages of briefing,
Right.
but that's.
13,000
what we got.
pages of depositions, exhibits. But that's what it does boil down to. And the short answer to the question is there was substantial compliance with the method. And
So we have no case law interpreting this particular provision. I know you all, your side, has relied on various authorities, but one that intrigued me was the reliance on the trust code, which, you know, is, I think, the basis for some model legislation type material, right?
you're
And-
referring to the Uniform Trust Code.
Yes, yes. And I'm not sure that the trust code does exactly what you all want it to do, because it emphasizes that delivery is sort of the gold standard. And I'm looking at my notes for exactly what it says, but I can't find them right now. I have a lot of notes because the record is so long. But I'm not sure
Hence the
that-
banker's boxes.
Yeah, it's the banker's box. I'm not sure that it gets you where you want to go, because I think that it also says whatever is spelled out in the trust instrument is controlling. And so then we get to the issue of, and I appreciate the difficulty both sides have with this, given the lack of authority on it. But you get to, you know, if you did 3 of the 4 things, but the 4th thing is perhaps more important, or at least as important as the first 3 things, how do we get away from substantial compliance? I actually looked around, I did sort of a 50-state survey on this to see what other states have done, or if this particular fact pattern had been presented for substantial compliance. And I don't want to ambush you with, you know, the results of a 50, what some kind of C-court said, but because I didn't find anything precise to this, but the general tenor of the case law, and I think starting with what you all relied on, the Uniform Trust Code, is that delivery is generally important. And I think your response to that is it didn't really matter. He either knew about it because Merrill Lynch, he had access to the Merrill Lynch document, the Merrill Lynch portal, or it didn't matter anyway because he really couldn't do anything because this was a revocable trust and he was shielded from liability if he did something in error. Right? That's, if I got your argument boiled down to.
And that is much of it. And we do rely on the Uniform Trust Code, and we do feel that it is quite helpful, unlike the trial court's conclusion. But we also relied on the fact that by the judge's ruling saying that you have to comply with each and every step of the method, as opposed to substantially comply with the method, that she basically rewrote the statute. That language is not in there.
Well,
And
that puzzles me. I mean, we have a method described in the trust document, and the method is comprised of a half a dozen steps. And I'm trying to figure out, I see the logic of what the judge did. You have to have substantial compliance with each step within the method. But if I were to just say substantial compliance with the method, what am I looking at?
well, you're looking at the whole method,
Yeah.
the entire method, and you're looking at not strict compliance with each step, because the amendment to the statute got away from strict compliance and wanted substantial compliance. And as Judge LaBritte said, we looked at the delivery as more of a technical requirement, because,
Well, I want to speak to you about that a little bit, because I did find my notes on the uniform trust code. That argument was made, that the delivery is a technical step. And then looking at the UTC, it gives an example of notarization as a technical step. It doesn't say that delivery is a technical step. And it also, and it does note, as I said, that giving notice is a good practice, but it doesn't require the giving of notice, and this trust does. And so that, I'm not sure, I just don't see where uniform trust code does much for you
well,
on this. And then I think we do have a question, like, if the notarization is a technical requirement, say the notary seal was defective, or she didn't get the ID that was required, or whatever. That would be, if you had a notary stamp it and sign it, that would seem like substantial compliance, even if the notary's commission had expired, or she didn't check off the proper method of identification. But delivery seems to be maybe a little more substantive, and particularly the way this trust was written with, if we look at it, and we are required to read the whole thing for context. Here, the trustees, this donor spelled out that, you know, the trustees had to, all actions were required to be by unanimous consent if there's two trustees. So that seems to give the trustee a little, what this trustee knows about what's going on, and then what happens later, which is the next step with the Merrill Lynch accounts, that this trustee was sort of left out in the cold, and that's not what the trust instrument was written to. And when I say left out in the cold, I mean ignorant. You know, we have to, your argument on what he knew from the Merrill Lynch portal is not really supported by any direct evidence. He denies knowing it. At best, it's a fact issue.
well, he denied knowing it, but it was because he didn't notice. It's not because he didn't have reason to know.
So that you are importing a purpose that I'm not sure is warranted by reading of the trust instrument. In other words, let's say he did have reason to see, oh, hey, you know, or he did know, like, wait, something's going on here. I can see the Merrill Lynch account. But the trust instrument says deliver a writing during the settler's lifetime.
Mhm.
So maybe there could be a purpose other than just, hey, by the way, I'm redoing everything. And that is so that the other trustee can see the writing. And maybe, like Judge Britt said, the notary's commission expired. Maybe that's you know, something that could still be substantial compliance. But isn't the purpose for the other trustee to see it? Say, oh yeah, this is, everything's on the up and up. I mean, especially in the context of this entire dispute here, couldn't there possibly be a purpose other than just a tip off?
Well, I would say really not, because there was no,
What about the fact that if this trustee doesn't know, right, because he didn't get the notice, let's just assume that the Merrill Lynch argument doesn't work here. So he doesn't know. The settlor then effectively disposes of the trust property, but it's still trust property, and the trust requires any such act to be by unanimous consent of the trustees. Now, I get that there's sort of the mirror image on that if Paul had himself wandered off and tried to withdraw funds from Merrill Lynch, he would be immunized. But under these circumstances, the settlor disposed of this trust property post-revocation without having the trustee acknowledge that the trust existed no longer, you know, that existed no longer. And I get that the argument is, well, the settlor didn't think he needed that, but the settlor wrote a trust that said to accomplish that, you got to give notice, you got to deliver it. So it seems a little circular.
well, I would respond this way. As far as the taking of the trust assets, I'm going to leave that to Mr. Wallace, because that goes more to the count 11 issues. But as far as the delivery and Paul's knowledge, first I want to point out that it's our position that there was some compliance with the delivery step, because there were two trustees, and Bruce partially complied.
By giving it to himself.
Yes.
Okay.
And
Suppose-
I know the
suppose-
judge rejected that, but
Suppose the statute did not insulate Paul from liability. Would Bruce getting notice be substantial compliance? When Paul is arguably out on the limb, if he should make a decision without knowing of the change in trustee?
not sure I understand the question.
As I understand it, the statute immunizes
Yes,
the co-trustee.
yes.
Okay, suppose that statute did not exist. Substantial compliance would probably then have to include notice to Paul to ensure that he doesn't do anything amiss. Would you agree with that?
Well, that is one basis for the notice, but there's also the fact that there was no basis for him to object during during Bruce's lifetime.
Let me take Judge LaRosa's question a step further. You know, what if, just presuming the world in which we live, that there's that liability insulation, you know, isn't it still pretty helpful for the other trustee to know that things have changed in a manner?
Well,
You know, I mean,
I
even if he
understand.
wasn't liable for things he could have done, operating under the false understanding that the trust was still operable in the way it had been before, isn't it, wouldn't it be important that he not do things operating under a false presumption?
Excuse me, Ms. Silverman, you're over 15 minutes, but let's answer this question, please.
Okay, I just want to point out that along this line, when Bruce amended the trust in September of 16 and added Paul as a co-trustee, he removed Judy Ludwig, who had been the long time since the trust was created in 2003, the longtime trustee. And Article 1 of that trust said Judy Ludwig was no longer a co-trustee from and after the execution of the instrument. Now, in Paul's affidavit filed in support of his motion for summary judgment, he said that he accepted as trustee on September 2nd, 2016, and served with Bruce as co-trustees after that. She was not delivered a copy of the 2016 amendment when it was executed. She found out later that she was no longer a trustee. Her deposition was a little vague about when she found out, but there was an email in evidence from one of the Merrill Lynch advisors.
Nobody ever challenged her service or termination of her service as trustee. And so kind of what difference does it make? And I mean, I get that, you know, too long to make it right, or let's point at somebody else, but I'm not sure it makes much difference.
Well,
Answer this question, Ms. Silverman, you're going to have to sit down.
okay. And I think it's important because it shows that in 2016, the trustees didn't think delivery to the co-trustee was that big of a deal.
Except for the settlement.
And as far as the Uniform Trust Code, I know I don't have any more time, but I would just like to say that the comments are really enlightening and helpful since we have no case law, and I think they support our position.
Thank you.
Thank you.
Mr. Wallace.
Good morning. I'm David Wallace from Bentley, Goodrich and Keeson on behalf of appellant Violetta Grassfield. I'm going to pick up with first a big picture thing, and then I'll touch on some of the issues on 10, and then I'll get to 11, because I know that's how we divided our time. First, the big picture is this is a revocable trust. It reserves the right to the settlor to amend. It reserves the right to the set. That's in 2A. It reserves the right to the settlor to withdraw his money up to all of it. That's in 4. That relates to 11. So the big picture is it's a revocable trust, and the result that we have below is Bruce Grassfield had two things in mind. He wanted to amend his 2018 restatement. That was taken away and undone. He wanted to withdraw his money in April of 2019. He exercised a writing at a time where he was a settlor and the trustee. That was undone.
Exercise writing, not, the thing that he signed doesn't reflect that he was doing it in his capacity as trustee, does it?
It does not, and I'll get back to that on my discussion of 11, but my point is that everyone knew he was a trustee, and the capacity in which he signed the letter can be a question of fact, and we cited to the, I think, HIMCO or something like that case. I'll have to find that name, but we argued it was a question of fact, the capacity in which he signed it, and when someone has two hats, that can be a question of fact, and it was particularly given that he was.
Well, the fact that he didn't sign it as trustee is obvious, isn't it?
Well,
He
he
didn't sign.
correct. He didn't
So-
sign as trustee,
Yeah.
but of course, the request pursuant to Article 4A is supposed to be a request coming from the settlor. It's a request for the settlor's money.
The invocation of that article in the request, or is that, am I misunderstanding your?
He didn't recite Article 4 in
It didn't
his,
say in that request pursuant to Article 4.
No.
No.
no, but he asked for his money. He's a settlor asking for his money in a revocable
Well,
trust.
that's the simple point. Everybody knew he was the donor, the
Exactly.
settlor, the trustee,
Exactly,
and it's his 10 million.
exactly. Exactly.
Okay.
And he asked,
But once he submitted that property to trust ownership, which he did do by creating the trust. And he wrote the provisions of the trust that would govern its administration and the acts that would be taken by the trustees. I asked your co-counsel, the follow-up on Ludwig, because I thought it would be unfair to jump out of the box at you for having not set the table for it. But I want to get you to the delivery question a little bit before we go to your Article 11 or your section count 11 argument. What if, one of the examples I think from some material I read here was substantial compliance with delivery might be mailing it and ineffectively, a misaddressed envelope or not enough postage or whatever. And in that instance, the trustee wouldn't have received the notice, but the settlor would have at least attempted delivery. And that would support, or at least there's some suggestion that would support substantial compliance. But here, correct me if I'm wrong, and there's 13,000 pages, so I might have missed something, but there was no attempt at all to deliver anything to Paul concerning the elimination of his status as trustee.
there are no summary judgment facts that I know of that reflect that he took a few steps towards the mailbox and didn't make it or something like that.
No evidence of any attempt to deliver. And can you
Correct.
review that?
Correct, but I think that gets the way your question and going back to an earlier question from Judge LaRose gets back to the whole standard applied by the trial court, which I think is the root of the problem, that the statute says substantial compliance with a method. And what the trial court ruled in paragraph
Well,
U,
but the trial
I'd like
court,
to-
we've read your arguments.
Can I want to hear the answer.
okay, and the trial court ruled in paragraph U of her summary judgment order that there has to be substantial compliance with each step of the method and no step can be missed. And Your Honor,
And isn't that partly because the language of the trust was conjunctive?
I don't think that follows from that. Because I think that the statute says substantial compliance with the method. And let me give an example from the UTC comments, and it's the same example you've used earlier, which is the notarization example, which is the notarization example tells us that a step can be missed. The trial court ruled that a step cannot be missed. This trial court ruled that you cannot miss a step.
She ruled that you can't miss this step.
She ruled that you cannot miss a step.
For your purposes here, the ruling. that
I
she-
think her ruling in paragraph U was clear enough that substantial compliance with a method demands substantial compliance with each step of the method and no step can be missed.
But isn't that argument academic? If this court determines that the step that was missed was important enough to vitiate substantial compliance, I mean, we could say all day long that perhaps that was an inartful recapitulation of the standard. I'm not saying it was or wasn't, but that, don't you still have to
Sure.
argue
Oh,
that
yes, yes,
completely omitting if
yes.
the delivery step?
Yeah, I agree. I think there are two problems here. First is the standard is wrong. And the standard is, she rewrote the standard, she added to the standard. And then I'm going to get to the second part in just a
Not
moment.
conceding that you did, but even if we did concede that,
Oh, absolutely. We do have to address delivery in the context of the right standard.
What she said was no step can be completely ignored. And I think we all agree it's conjunctive. That means each of the requirements, whether you call them steps, elements, factors, whatever. It's conjunctive, so something has to happen for each of them, which leaves you with the compliance for purposes of delivery was substantial by virtue of Bruce having given himself the note, or Bruce having given himself the notice, right?
Well, I don't agree that her standard is correct, that there has to be substantial compliances to each step. I think she's wrong about that. I don't think that the conjunctive causes that, and I think the notarization example demonstrates that. I lost the thread of your.
Well, to stick to what's wrong with, according to you, paragraph U of the order. And
Right.
why it's mischief that Lawrence reversed.
Right.
Is the sentence that reads, demand substantial compliance with each step. Of the
Right.
method, and no step can be completely ignored. But the only step we're focused on here is delivery. And in the notary hypothetical that I gave, it wasn't ignored, there was an attempt at compliance, but
I was making reference to the UTC example where notarization was just missed. There's no suggestion in the UTC comments that you can't theoretically miss a step. And I think that at the root of this is that the standard is wrong because she added to it and
well,
rewrote it.
UTC is very general, and it's not necessarily, I don't think it said anything about when you have conjunctive requirements.
Well,
didn't see
I think
anything.
probably most step methods are probably in the conjunctive. I don't think the conjunctive changes this. We acknowledge that in the totality of the method, delivery is one of the steps. And what the legislature passed in passing 736-0602-3A in 2007 is there has to be substantial compliance with a method.
you're saying in the abstract, there could conceivably be a scenario in which a step was ignored, to use the language of the
Yes.
trial court, and it could still constitute
Yes.
compliance. Like if it was put your right foot in, put your right foot out, put your right foot in, and then
Yes.
shake it all about. If you didn't shake it all about, and that wasn't very important.
Exactly.
But okay, but then so why is
Okay.
delivery not is the equivalent of shaking it all
Okay.
about? And that was supposed-
Okay, a couple of points on delivery. First of all, it highlights the fact that the court did not just get the wrong standard. The court got the facts wrong. If you look, I can't remember which paragraph it is, but the court said 3 or 4 times that there was nothing done as to delivery, nothing done as to delivery, nothing done as to delivery. That's wrong. It's
Because he
factual.
delivered it to himself,
Correct. Correct.
but he already had it.
He already had it, but I think if we
It's
call
not
it,
delivery.
well,
How
if
can
you,
that be considered?
judge,
delivery?
if he was a sole trustee of his own trust, sole trustee, no one would say,
So let me ask you this, let me concede, okay, sorry.
I'd like to hear him.
no one would say that he didn't deliver it to himself and therefore it's invalid. He's one of the 2 co-trustees. And if we're going to take note of the co-trustee, I think we have to treat him as a co-trustee. He was
So
one.
let me concede your argument then. In other words, that was delivery and you
Well,
know,
it's
the
partial.
ordinary meaning of delivery was satisfied. The only effective requirement, consequential requirement, a requirement with any effect or purpose was delivery to the other trustee, and that was omitted. In other words, by completing a actual vain, inconsequential, unnecessary act of delivering to himself something he had just executed, you're saying that that's substantial compliance?
No,
You
I'm not.
omitted the
I'm saying
only
it's not
actual-
nothing. I'm saying it's not nothing. I think the trial court repeatedly called it nothing. And if you look at her standards, she says no step
So
can
we're
be
gonna
missed.
reverse by saying, you know what, you called this nothing, even though it's
No.
completely ineffectual and purposeless.
It's just one piece of the puzzle. It's a combination of the standard plus the mistake in in the fact, but as to delivery, first of all, there's the liability issue, which I think Judge LaRose started a question, Judge Atkinson picked it up earlier. On delivery, if we didn't have that subsection 7 that gave liability protection, it's another section imported from the Uniform Trust Code. If we did not have that, would this be a closer call? I think yes, but we do have it. So the other trustee is protected from liability. That's
So that
part
just
of it.
obviates one potential harm of not notifying a trustee.
That's correct.
Can you think of other harms?
Well, the other piece of it is that this is a settler's choice to amend his trust. It's not a democracy. It's not a vote. The trustees don't get to vote whether whether the settlor gets to amend his trust. This is the trustee.
Still waiting for the whether the answer is there another purpose? You're saying you have to be saying it's purposeless to.
No, I think it's better than not. I mean, I think you mentioned some things earlier that would it be better that he knew? Sure. We happen to know in this case that a whole year passed between the 2018 restatement and when Bruce Grassfield died. And Paul Grassfield didn't notice he wasn't a trustee. He wasn't doing anything as trustee. So that's one fact. But the main point is that this is not a choice or a permission or a consent on behalf of the co-trustee. This is the settlor's decision to amend his own trust. So it is a notice. Delivery is notice. Is it better than no notice? Yes, it is.
For what reason? I won't ask you to make your argument.
Yeah, I mean, you'd have to imagine circumstances where he might have.
What about circumstances in which the specter of undue influence and the lack of capacity is at issue? Would that be a reason?
You can't bring a trust. Well, this wasn't, they didn't identify what their reasons, what options Paul might have had. But you can't bring a trust contest while the settlor is alive and the trust is still revocable. You can't do that.
Mr. Wallace, why don't you get to
Get to 11?
count 11?
Okay, I will.
We've beaten you up here. on,
That's
The
fine.
other issue.
Count 11 is first of all, the factual setup for that, of course, is that it happens in April of 2019. So we're after that 2018 restatement. By that time, Bruce, the settlor, believes that he has removed Paul as his co-trustee. He asks for his money. He asks for his money as any settlor of any revocable trust. There's typically a provision to get your money out of your own revocable trust. He asks for his money. The provision in our case is Article 4A, which says during the lifetime of the donor, the trustee shall apply the net income and principal from the trust, including the whole thereof, as the donor may from time to time in writing request. So this is a request. It's not supposed to be a request from the trustees to Merrill Lynch or something like that. It's a request from the settlor. This is the settlor of a revocable trust. He's still alive. It's his money. He asks for his money. And so that's Article 4A. He makes the request for his money. And the court made two rulings under two different theories as to count 11. Only one of them, as we stated in our brief, was part of count 11, and that is the theory that his withdrawal should have been treated as attempted revocation, but it failed as a revocation and therefore should be undone as a failed revocation. And our argument on that is simply this: it was not an attempted revocation. It was not intended as a revocation. It was not a power exercised by him to revoke. He intended to not revoke. He intended just to withdraw his money. And
Well,
perhaps,
if he took out all his money and left $5 in the trust, it's still an existing trust.
yes, so he's not revoking his trust. And more importantly, perhaps, is under 2A. There's that phrase that I used a lot in our brief, terms and provisions. This is not an attempt to revoke the terms and provisions of his trust. He was taking money out.
Doesn't it say terms and provisions and the trust thereunder? I'm sorry,
Yeah,
it said terms and provisions and something like, pardon my ignorance, but and then it says, or the trust itself, essentially.
right. And I think that you could revoke, for example, part of their trust, but there was no change to terms and provisions. It was just taking money out.
Right, but let's say you just hollowed it out, because there's nothing left in the trust. Is that, would that be a revocation, because the terms, provisions of the trust and the trust hereby created? So in other words, you could reserve the power to revoke
I don't think so.
ellipses, the trust hereby created.
My understanding is you can have a trust with no money. But he was advised by his lawyer, don't revoke your trust. He talked to her about it. She said, don't do it. So he went to take his money out. So he wasn't trying, he didn't notarize his letter to Merrill Lynch or anything like that, trying to comply with his method for revocation. So we think the trial court erred as to argument A by treating it as a revocation. It wasn't intended as a revocation, didn't change the terms and provisions. He wasn't trying to comply with the steps. He was trying to withdraw his own money from his trust, leaving his trust intact, including the terms and provisions of his trust. So that's argument A, and I know I've been using a lot of time, so I'm going to get to argument B.
You're make it.
I'll be brief. Argument B has two parts. One's procedural, one's substantive. The procedural part is that Paul's motion for summary judgment was expressly limited to counts 10 and 11. The argument that is argument B is an argument that appears in their reply. It is not, the reply was not identified in the motion for summary judgment as a basis for the motion for summary judgment. It is a different argument. It is not based on Article 2A of the trust. It is based on other pieces of the trust. And the other piece, it gets us to Article 4A, which is the argument that I've made, not even quoted, not even referenced in the trial court's motion, order on motion for reconsideration. But Article 4A says that you can ask for your money and the trustee shall comply. So then we're back to the question again. Again, Bruce didn't know that Paul was still a co-trustee, but if you assume he was, and if you assume he handed him this letter and said, I'm taking my money out, this is not a unanimous decision context. This is the trustee shall comply. This is a ministerial act. This is not a vote. This is not even a decision. This is the settlor under a provision of his trust, Article 4A, asking for his own money and doing so in writing, as Article 4A says the settlor can do. We have the complication that he didn't know Paul was a co-trustee at the time, but even if he handed it to him,
A settlor is supposed to ask.
it's not an ask with a permission, though, Your Honor. It's
Who's he supposed to tell? Hey, give me my money.
well, Article 4A. During the lifetime of the donor, the trustee shall apply the net income and principal from the trust, including the whole thereof, as the donor may from time to time in writing request.
The trustee.
The trustee.
There's no one else.
There's-
Tell the trustee.
There's no one else, but remember, Bruce, and this gets back to one of the first questions we had with Judge LeBret, which, Bruce was the settlor and a trustee of his trust. And so he's asking for his own money. And
Asking who?
well, well, in this, maybe I misused the word ask, Your Honor. In this instance, he's directing Merrill Lynch to move his money.
But he's really
To a different
effectively directing the trustee, right? Supposed to be directing the trustee.
He is the trustee.
He is a trustee, yeah.
But if Paul's the trustee as well, isn't he supposed to?
And Paul would have had no choice but to do it. It would not be that they would not have had to have a meeting or a decision or anything else.
Thank you,
And
Mr. Wallace. Let's wrap it up.
I will. I think that the big picture here is that as we view it, if this decision stands, or if the court writes an opinion consistent with the lower court's opinion, it changes the way people would look at revocable trusts. It changes who you can have as co-trustee. It changes what your expectations are with your own money. And more to the point on substantial compliance, there was a change from strict compliance to substantial compliance. There's not much room there for what substantial compliance is. So thank you, and we'll divide up our rebuttal time when we get to that point.
Thank you, Mr. Wallace. Ms. Bald?
Thank you, Your Honor.
May it please the court,
Kim Ball. I'm the law firm of Carly and Bald in Bradenton. I'm here with Aaron Crittenden, and we have the pleasure of representing Paul Grassfield in this proceeding, both individually and as trustee.
If let me ask you something. If Bruce had named Paul and Bank of America as co-trustees, and then he decides it's going to change, and he sends a letter to Bank of America, but he doesn't send it to Paul, is that substantial compliance with the delivery?
I would say no, Your Honor, because you have to look at the rest of the trust. And,
Okay.
and the terms that Bruce Grassfield put in his trust are what control. He said there shall always be two trustees. That's the way it's been since 2003. In the 2014 and the 2016 trust, he said the trustees shall act unanimously. It's not make decisions. They shall act unanimously. For some reason, the judge didn't want to speculate, though she was asked to speculate. She said, I could speculate that he put that provision in there requiring two trustees to act together for protection. But I'm not going to speculate to that because I am going to follow the terms of the trust that the grantor wrote, because that reflects his intent. And so throughout this trust from 2014 and 2016, he chose to have two trustees. Two trustees must act and required notice to both of those trustees for everything. If he had revoked his trust, even if it was just a partial revocation, he had to provide the instrument in writing signed by the donor, acknowledged before a notary public, and delivered to the trustees during the donor's lifetime, which contemplates someone other than the donor. And even if it was just a partial revocation, it says in the event the donor shall revoke this trust, the trustee shall transfer and pay over the trust estate or such portion thereof to which said revocation is applicable to the donor as the donor may direct in writing. So we don't have any writings from the donor to the trustees under either count.
And that sort of goes to the propriety of the trial court's resolution of count 11, right?
Yes.
That, and what I think she found was that after saying to the extent this would have been a revocation or could have been a revocation, it was ineffective. But nonetheless, and this is in, I think, the order on reconsideration, she found it to be, and based on what she characterized as undisputed facts, that Bruce lost his individual ability to transfer or withdraw funds from the Merrill Lynch account when he settled that.
He didn't lose the ability to have them withdrawn. He no longer could do it individually.
Right.
By transferring it into the trust. It's now, just like the real estate, it's now titled in the name of the trustees.
Right, so which is why Paul needed to know and why Paul needed to be part of the withdrawal from Merrill Lynch. Am I
Yes.
following your argument?
Yes,
Okay.
yes, yes. So looking at the first argument on the substantial compliance, and I think that the court's questions have really addressed much of what Judge Moreland determined. The and means something, and the language, the wording after and means something. Again, that was something that this grantor included in his trust, that the courts even asked counsel for appellant Violetta Grassfield, are you telling me that this doesn't mean anything? That I as a trial court should completely disregard the fact that this grantor added this additional language in his trust in order to amend, restate, or revoke?
What would have been, in your view, what would have constituted substantial compliance with the delivery?
You know, I want to go to their argument about the 2016 trust to answer that. Because they've tried to argue the 2016 trust somehow, because it wasn't, you know, there wasn't the trust delivered to Judy Ludwig, that somehow that makes that the 2016 trust invalid. I want to point out they don't, none of the appellants are going to challenge that 2016 document because they're not in the 2014 documents, and it wasn't challenged. But that the evidence was clear that Judy Ludwig was provided an email from Merrill Lynch with a copy to the set grant of the donor.
Ludwig, I don't think anybody argued this, but in reading the knowledge statute, it struck me that, you know, there's a provision for corporate knowledge. And I wondered, is there a reason why Merrill Lynch and Judy Ludwig was only in this job because she was at Merrill Lynch?
She was not at Merrill Lynch.
Okay.
No, she was at a different, actually,
Boston
she was the
Financial.
one that was removed after the relationship resumed again all of the professionals were removed, and Judy Ludwig was one of the ones that was removed, and they moved all the money over to Merrill Lynch. So she was the investment advisor up until
Braver.
2016. Yes,
Okay,
yes.
so did Merrill, how did she find out?
So Merrill Lynch, through Chip McConnell, sent her an email advising her that the trust had been amended and she was no longer the trustee. And he provided her with the names of the trustees, which were now Bruce and Paul Grassfield. That was copied to both Paul and Bruce Grassfield. And when we asked him in his deposition, was that email sent at the direction of Bruce Grassfield, he said, Merrill Lynch doesn't notify trustees, so I only do that when I'm instructed to do so.
Obviously, Bruce's lifetime.
Right, so he was, so
So-
that would
and
arguably,
So,
But see that.
that could have been substantial compliance.
Well, that's strict compliance.
Well, it's,
Is there anything short of actual delivery that would constitute substantial compliance in your view?
well, she didn't receive a copy of the trust. She only received an email advising her that it had been amended and that she was no longer the trustee. She never received a copy of the trust.
Or correct me if I'm wrong, isn't it the signed writing that she's supposed to receive?
And yes, and so I think you would have an argument there if the 2016 trust had been challenged. Is getting an email substantial compliance?
Okay.
But that was never challenged, so it really was never litigated by the court.
But we would be having a totally different conversation if Bruce had emailed Paul
Correct,
and said, by the way, I've amended it, you don't get a copy, but you're out.
correct.
We would then have to determine whether that would be substantial compliance because the instrument wasn't delivered to Paul,
Correct.
but he had knowledge.
And it
Correct.
was very clear here. There was no effort made. I know they try and argue that he was getting bank statements. The unrefuted evidence as to knowledge is that he was continuing to get bank statements as though he was still a trustee. And he never saw that his name was not on the statements. That's been unrefuted. So if the evidence was unrefuted, that there was absolutely no effort made to provide any notice to Paul
Let me ask you a
Grassfield
question
during
about this statements. Was he viewing them online or were they being mailed to him?
online.
So.
Do we have evidence as to whether he had continuous online access or is that just an assumption?
I think he said he looked at them periodically and he continued to receive them.
Regarding the latter transaction, even if I presume that the trustee means trustees and it's the trustee who shall apply the net income as the donor effective time to time and running requests, which I could even infer that writing must go to both trustees. But what about the evidence that he'd been taking money out of the trust prior to this transaction?
The only evidence of that, the evidence of this the way this trust was structured was this was an investment account. The only evidence that any checks were removed was one bank statement, 1 month. And I think it totaled $4,200.
But Paul testified, didn't he, that he assumed his father was writing checks to himself episodically or occasionally?
I think it was he knew his father had written a check on occasion. He also testified that this was not the bill pay account, that Judy Ludwig was paying all the bills for his father, that there was a separate bill pay account at Boston Private Bank, and that was the bill pay account, and that the purpose of this account was an investment account to grow equities. There's no evidence of who wrote those checks. There's no evidence if Paul even saw those checks. It's just one statement that they filed in opposition to the motion.
Would you say that type of withdrawal would violate Article 4?
It probably technically would. The way this trust was written, yes. The way this trust was written, because it does require the joint act of both trustees. And I would submit, since it isn't a bill paying account, and that was clear in the evidence, there obviously was a reason why Bruce Grassfield wanted 2 trustees at all times and required the joint action. As to the delivery to Bruce Grassfield, he was the donor as soon as he signed. I mean, and that's just not delivery
So
to the
under your
trustee.
theory, there was no affirmative step taken in any respect.
That's correct.
To comply or in any manner with the delivery requirement.
Absolutely none. Absolutely none. And under the statute, substantial compliance requires some effort to satisfy the rest of the method after the word and. I'm not going to mention on the UTC. I think this court has already,
Well, would you go back a moment, if you would, address Mr. Wallace's point about substantial compliance with a method as opposed to substantial compliance with each step of the method?
I think it's interesting in their brief, they concluded with it has to be substantial compliance with the entire method. And if you look at the first part of the method that Bruce Grassfield put in his trust, it's in essence what would be necessary in order to amend a trust. It's a writing signed by the donor. In this instance, he says notarized, notarized versus two witnesses. The two witnesses that's what's basically required in order to amend a trust. I mean, that's what Florida law is. So that's the basics. Bruce Grassfield added an additional requirement and delivery to the trustees during my lifetime. So as the judge said, as Judge Moreland said, those are the words of Bruce Grassfield. Those are the words of the grantor in this trust, and I am to discern the intent and of the grantor from those words. And that was his requirement, and that is a substantive requirement.
Well, he didn't have to have two trustees, did
He did not.
And
He did
didn't
not.
have to give them unanimous.
He did not.
He didn't have to impose a unanimous requirement on their actions.
He did not.
Those were things that he chose to do.
And had he chosen to be the sole grantor and the sole trustee, then he has this is a completely different case. But he always chose to have two trustees, and here he chose that both trustees had to unanimously act.
What about the argument made by the appellants that effectively it was, well, I don't want to put words in their mouth, it's one trustee, they didn't say that, but they said because the trustee, the other trustee, had no right to refuse a directive if it had been in writing, and let's say Paul still had been the trustee, if he as the donor had put in writing a request to apply the net income in X manner, that because that other trustee had no discretion to deny that request, that is a step that is dispensable.
Well,
Notice is a step, or even compliance with Article 4A is dispensable.
well, then it's basically saying you can ignore what the grantor required. That you can then rewrite the method,
But they're
or you
saying
can ignore the
he is
method.
Grantor saying, I want my money now.
but that's not what he wrote in the trust. We're following Bruce Grassfield's directive in his trust. Now, at the hearing, when they raised that argument, we said, we don't know what Paul Grassfield would have done had he received the document showing that it was going to be amended or restated or revoked. We don't know what Paul Grassfield would have done had he received in, I think it was May of 2019 when the $10 million was pulled out. Had he received a directive. This case was also a lack of capacity case. So we'd be speculating at what he did, but we argued it at the hearing before Judge Moreland. He had options. He had an option to challenge the capacity of the grantor at that point, bring a guardianship action. But we don't get there because he never received the notice. And again, that's all speculation. Your Honor, as to the count 11, we addressed the letter in two manners in the motion for summary judgment. I've actually cited to the motion itself and the supplemental authority that counsel for Violetta Grassfield provided specifically requires us to detail in the motion the basis for the motion. And I would submit that I would say the motion for summary judgment set forth in detail this argument at 1474.
Paragraph 63 and 64.
Yes,
right?
it's also, it starts in paragraph 2. Paragraph 2 of our motion, we summarize the relief that we're requesting and as to count 11, and it's specifically that April letter did not withdraw those assets and they remain subject to the trust. 1485 was paragraph 36 in the motion, and
This
then
issue was never raised until the motion for clarification. Am I
it
right?
was, it was in our motion to this motion for summary judgment, and it was argued.
I mean, the deficiency.
That's correct.
What they're relying on.
That's
was not
correct.
raised until after the decision.
That's correct. And if you look at even the transcript of the hearing at 11364 through 11366, that's Mr. Schwartz, who represented Violetta Grassfield at the summary judgment hearing, argued this exact issue. So it was well argued and resolved. So we addressed the April letter in two manners. Because of the case law that says a full revocation is constant, or withdrawal is akin to a revocation of the trust. And so we addressed it first as to whether that letter complied with the revocation requirements of the
Would it have to be all removed or some portion?
I think it was, he directed that all of the assets in the one account, which was a trust account, be transferred into an individual account.
Okay,
So all of it was taken out.
but something less than all of it, would that be a revocation?
It would be a partial revocation. And if you look at the
As
cases,
to the money withdrawn.
yes, as to the money withdrawal.
Okay.
And if you look at the Siegel versus Novak decision, they argue that that's New York law, but that was also approved by Schlossberg versus the state of Korsky that we've cited. In the Siegel case, they specifically said a settlor trustee's withdrawal of funds from a revocable trust is tantamount to a revocation or termination of the trust with respect to the funds drawn. And they specifically also note in this case and in the other case, one of the central characteristics of a revocable trust is that the settlor has the right to recall or end the trust at any time and thereby regain absolute ownership of the trust property. And that was, I think, Judge LaBrette, that kind of relates to your comment earlier. The case law discusses once you transfer assets into the trust, it's now the title holder are the trustees, which is why the requirement in the trust, if the grantor then wants to withdraw his $10 million and basically end this trust, it requires the written directive to the trustees, and then the trustees are the ones that make the transfer. We cited a number of cases where the trustee, in one case, the trustee and the settlor signed a deed. That was a valid transfer because the trustees were on the title. We cited another case where only the settlor grantor signed the deed, and they said that was ineffective because once they transferred that property into the trust, it was no longer their property. So we walked through how the letter itself does not comply with the revocation requirements of the trust. So the letter itself did not constitute a revocation. We also, and the court properly held that that letter did not validly withdraw the assets from the trust. The letter was prepared by Merrill Lynch. It was sent by Merrill Lynch with the form signature place. It was signed. Who asked for it? Who sent it? Again, that was a disputed issue, but it was signed by Bruce Grassfield in his individual name. It was sent to Merrill Lynch. It was never sent to the trustees. Here, that Article 4 that appellants rely on, it requires written directive to the trustees. At no time did the trustees ever get a written directive asking for funds to be withdrawn. Again, it was signed by Bruce Grassfield individually. Even if he had signed it as trustee, which he did not, that would not have been effective to withdraw those funds from the accounts or from the trust. The trust, again, the transfer required the signatures of both trustees under Article 7J and 736.0703. It required the unanimous act of both trustees. Again, a requirement that Bruce Grassfield put in his trust. We again cited to the Schlossberg decision, which again, they recognize that it's the settlor has the right to revoke and terminate a trust to regain ownership. It's regain ownership. They don't have ownership. And that was the case where the deed was signed by both the trustees. Again, the and when I referenced in the hearing that we did talk about the options that the trustee Paul Grassfield would have had, that is cited at pages 11796 of the hearing. And under their argument, under both arguments, they're asking for Bruce Grassfield's provisions in his trust to be ignored for the method. They're asking for Bruce Grassfield's trust provisions that require two trustees to unanimously act to be ignored. And they're asking for Bruce Grassfield's requirements in this trust of delivery to the trustees to be ignored. The trust provisions were not met, and those trust assets remained assets of the trust. I do want to mention too, and I think it also relates to some of your questions. Counsel for Violetta referenced this being a Pandora's box. And I think you have to look at this trust versus other options for trustees and settlors. If a settlor wants to retain absolute control of the assets he or she are putting into a trust, then the terms are going to be different than what Bruce Grassfield provided. They're the sole trustee, they're the sole settlor. But in this instance where you have a separate bill pay account for Bruce Grassfield, he chose to put in the provisions that required the two trustees, notice to the two trustees, delivery to the trustee in order to revoke, amend, or remove these trust assets. The case law and the statute are very clear that the intent of the settlor as set forth in this trust is paramount. Judge Moreland's motion for summary judgment enforced that intent, complied with the law, properly construed and applied the statute. And we would respectfully request that this court affirm Judge Moreland's ruling as to both counts. Thank you.
Thank you, Ms. Fuller. Ms. Aberman and Mr. Wallace, how?
I think I'm taking the time.
Okay, 5 minutes.
Or we agreed I would take the time, and not just,
5 minutes?
yes.
Okay, thank you.
So I'm going to jump around in responding to a number of points here. We're not asking for the court to ignore the provisions of his trust. As to count 10, we're talking about substantial compliance, and it has to mean something. It has to mean something other than strict compliance. It has to mean something other than strict compliance. The Florida legislature changed it in 2007. No court has interpreted it. We know from the Uniform Trust Code comments that there are circumstances where steps can be missed. This court interpreted substantial compliance that no step can be missed, and that there must be substantial compliance with each step. That's not found in the Uniform Trust Code. We're not asking the court to ignore his trust provisions. We're asking, as to count 10, we're asking the court to consider substantial compliance and to apply substantial compliance using the words that the Florida legislature used. In our reply brief, we cited a couple cases. One was Westfall, that courts are without the power to rewrite a plainly written statute. The next case that I cited in our reply is the Fitz case, which is a homestead case that I lost before this court a few years ago. And Judge LeBreton came up in the argument that we had with Ms. Bray a few weeks ago. The last paragraph of the Fitz case, Fitz opinion, written by Judge Black, we are bound by the laws as they were passed by the legislature and not allowed to add language or fill gaps in the statutes. And we strongly believe that's exactly what the trial court did here. She rewrote the statute, she added language, she didn't say substantial compliance with a method, she said substantial compliance with each individual step of a method, and no step can be missed. And Judge Atkinson, you and I have had a discussion about delivery. Is delivery meaningless? No, we don't think delivery is meaningless. We just believe that in the context of substantial compliance, which, by the way, the whole purpose of substantial compliance is to increase the odds of effectuating a settlor's intent.
So what do you think? What do you think the method is?
What do I think the method is?
Yeah, the method.
It's the entirety of, it's all of them together.
What is it? What's the purpose of that method? You know, what does that add? If you take out delivery to the trustee, what's the method?
He has to put it in writing, he has to sign it, he has to notarize it. I mean,
How much different is that than a typical trust, or, you know, I mean, this is a specific provision that kind of added to.
well, it's a specific provision. I'm not sure, frankly,
Added to the norm.
there was a lot of discussion about it being added. I'm not sure we should be engaging in speculation of how important he thought it was by adding it. You know, we're talking about it as if Bruce Grassfield sat around and thought, boy, delivery is really important, I'm going to add that. you know, it's equally.
Don't we have to assume that he wrote it down for a reason and give it some meaning?
Well, like, we are giving
I
it meaning. Our point is to give it meaning in the context of substantial compliance with a method. And our position would be that we don't give it outsized meaning because it's because he added it. And my suggestion was going to be that perhaps his lawyer's form includes delivery. I don't know. I don't think that there was evidence as to how that came to be. But I think what we do have is what is substantial compliance if this is not it?
But we have the example, right? We had the opposing counsel brought up the example of the 2016 transaction, which y'all impugn and, you know, and your.
That an email was sent instead of a delivery. Right, notification instead of delivery. Well, Judy Ludwig, by the way, said I never received any deliveries. So that, you know, so I don't know. I don't think that that's that nothing in the UTC comments that say to me that you have to look at each individual step and have to do, I'm going to use air quotes, some effort as to each step. I don't think the UTC comments say that. There's no case law authority that says
Isn't
that.
The fundamental component of substantial compliance generally across the body of law, not this particular statutory provision. But substantial compliance requires some affirmative effort to achieve the prescribed method, steps, requirements.
It does, but I think that's the difference from looking at it as a whole, as the legislature wrote it, substantial compliance with the method, and looking at it in individual steps, because Bruce Grassfield did make an effort to comply with this
the
method.
legislature said was if the donor prescribes a method, it has to be substantially complied with. I don't think we're in the territory of people rewriting statutes here. But the question is, what does substantial compliance require? And my read of the general case law is some type of affirmative act that is similar or closer to conforming with the specified.
And we believe he did so because he did, again, I'm looking at it as a whole, which I respectfully disagree. I think the legislature said substantial compliance with the method, and I think the trial court's tweak on that, each step, is different. You come out with a different result, and Bruce Grassfield's compliance with putting it in writing, compliance with signing it, compliance with the other steps of his method, and yes, even delivering it to himself is not nothing. It may not be the be all and end all, but it's not nothing.
What if there were 10? What if there were 10 trustees and he was the 10th and he just didn't deliver to all 9 of them? Does that change the calculus? You're saying he delivered himself, so he delivered it to 50% of the trustees?
I don't know if that changes.
Even if I accept
It
that.
might change it a little bit.
Well, if he delivered to himself and he only delivered to 10% of the trustees, does that change substantially?
I think it might change it a little bit, but there weren't. And in this instance, you know, he didn't do nothing as to delivery. He fully complied with every other step. And again, I respectfully disagree. I think we are in the area of the trial court rewriting, because the trial court said no step can be missed. I don't think the legislature said that.
Whether the trial court's rewriting that depends entirely on your interpretation of the word method and whether steps are collective or individual. I think the legislature didn't parse it out quite that far.
The legislature didn't parse it out, but I think they may or may not have been wise in this instance, but by making it the method as a whole, the legislature
Well, the
avoided.
legislature didn't say that. The legislature
Didn't say as a whole.
the method as a whole.
It said
So
a
now
method.
you're
It said a method. It said a method, but it doesn't say individual steps of a method. And my point is that if you make it individual steps of a method, you're leaving yourself
Well, when
open
the
to.
donor specifies individual steps and makes them in the conjunctive, the legislature has directed that be followed.
The legislature has
Substantial
directed that
compliance
there
is
be
what is
substantial
required.
compliance with it.
Yes.
Not that each individual step, not that there be substantial compliance with each individual step.
This is the
And-
case.
And it is the whole case, but my point was that the legislature, by saying a method and not each individual step, and no step can be missed, whether in their wisdom or not, avoided the kind of pitfalls that maybe we're seeing here, but where you might have a step that somebody just misses. There are a lot of steps you can't partially comply with. And if somebody misses one, then you're out of the game by
Like
this.
you either have a written instrument.
You
or
either,
don't.
you either have a written instrument or you don't. That's the perfect example. You either sign it or you don't. And you don't try to sign something, you either sign it or you're done. And if you don't have, so that's the point, that it should be substantial compliance with the method. We do maintain that it rewrites the statute. Couple other comments.
Yeah, Mr. Wallace, you have to wrap it up.
I'm going to wrap it up as to their argument B on count 11. Their reply is not a claim for affirmative relief, and that's what they got from their reply.
It's a pleading though, isn't it?
It is a pleading. I agree. It's a pleading, but they got affirmative relief based on a 1-paragraph reply that doesn't cite a statute, doesn't cite a provision of the trust. There is no Florida case that says a tacit revocation of part of your trust by virtue of a withdrawal of some of your money requires that you comply with the substantial compliance analysis. That would be that's a new step by the trial court. And it would be a new step by this court. You know, and then Ms. Bald was talking about, you know, ignore parts of the trust. But I think we need to remember is we're talking about a settlor. We're talking about the rights of the settlor to amend his own trust and to withdraw his own money. Article 2, Article 4. And so in the trial court's ruling as it stands, those are the rights that are ignored. And so that's what I'm addressing here, and where we're asking the court to reverse such that the settlor's ability to control the disposition of his own assets is not ignored. Thank you.
Thank you, Mr. Wallace. Thank you all. Very well argued. Interesting case. That concludes our docket for this morning, and we are adjourned.
All rise.